I want to welcome you all here this afternoon to the Moneyball for ITC Litigation webinar hosted by Owen, Byrd, and Bert, Reiser. By way of introduction, Owen Byrd is Director of Sales and Marketing at Lex Machina, which produces IP litigation data and analytics to companies, law firms, and public interest users. He's previously founded and led data-driven software, real estate, political, and non-profit ventures, and operated his own law firm. He's a member of the California Bar and earned a JD from the University of Chicago Law School and a BA from the Colorado College. Bert Reiser is a partner in Latham & Watkins' Washington, D.C. office, where he's a member of the firm's IP practice group and International Trade Commission patent litigation practice group. Prior to joining Latham, he was head of a multinational law firm's Section 337 practice, where he was involved primarily in international intellectual property disputes before the United States International Trade Commission under Section 337. Mr. Reiser has extensive experience in district court patent litigation throughout the United States and is a repeatedly recognized attorney by Chambers USA. I'd like to welcome everybody here today. If you are interested in asking a question of our panelists today, may I ask that you use the chat box, which is the second icon in your little Join Me taskbar, to ask a question, and I will relay that to the participants at the end. This session is being recorded, and our participants have also agreed to make their slides available after the session. So if anybody's interested in that, you can please email me at matt@momentumevents.co. With that said, I'm going to pass the presentership over to Owen for you to commence the presentation.
Again, the topic of today's conversation is what we call Moneyball for lawyering, in this case Moneyball for ITC litigation, and how data and analytics can improve your participation in ITC investigations. So just by way of background, the reason we say the word Moneyball is it's become a shorthand way to describe decisions that are based on data and analytics. And it is important to first understand that data is just a collection of facts, while analytics is a way of discovering and communicating patterns within those facts. And data and analytics have been sweeping the nation and the globe in terms of transforming various professions and industries, from healthcare to marketing to politics to business management. And it is now being applied to law. So lawyers like us typically have done two things. We do research, we do reasoning, we combine them to advise clients. Now there's a third leg of the stool. There's data and analytics, and it can supplement the research and reasoning to improve lawyering. Who are we to say so? Well, our company is Lex Machina. We started as a project of Stanford Law School and the computer science department, and first bite at the apple here has been around IP, specifically patent, including in the district courts and at the ITC. So what do I mean by Moneyball for lawyering? As I said, it supplements traditional research and reasoning with data-driven decisions or predictive analytics, so that you can use the data to attempt to predict how a party or opposing counsel or a judge will behave. And in addition, you can predict what results a specific strategy or argument will produce. And analytics is merely different ways of looking at these different data sets. So our district court data includes over 130,000 IP and antitrust cases going back to Jan 1, 2000, and then we build unique metadata sets about parties, about law firms and attorneys, about judges and districts, about patents that have been asserted or cited, and the outcomes in those district court cases. But for today's conversation, we're going to focus mostly on what we are building for data and analytics around ITC investigations. We have every single investigation in the system, including all of the available EDIS docs. And we are in the process of building metadata sets about the parties that the law firms and attorneys, the ALJs, and the patents at issue. So with that, I want to turn it over. You'll see now that the format of the slides has changed, because what we want to do now is switch the presentation over to Bert, who's going to run through some of the substance of strategy and participation in ITC investigations. And you'll see as we go that there'll be places where you can identify where analytics might supplement the traditional research and reasoning. And then Bert will throw it back to me to look at a couple of examples, and I'll pull up the product line and answer any questions you might have. So Bert, it's all you, and I can either keep moving the deck forward or switch control to you.
So I don't think they've sent it over to me yet. So if you don't mind just clicking through, let's just stay here on this slide just for a moment. I just want to explain to folks a little bit about how we sort of got here. This is the second time that Owen and I have done this presentation. We did it, I think it was in May, perhaps June of this year. And it had a different look to it. It was kind of a traditional, here's the ITC, and here's the stuff you ought to talk about and think about, and here's how you should plan your case, and here's all the stuff that happens in an ITC case. And it's the kind of presentation I've done, for better or worse, maybe 100 times in my career. And meeting Owen and sort of getting a feel for his sort of view of our profession and the things that we do every day was really, really interesting. And so what we're trying to do here is talk about the ITC, talk about strategies in the ITC, talk about things that you ought to be thinking about and how you ought to plan your case, to the extent we can do that in an hour. And more, Owen is going to jump in and talk very specifically about how data and analytics can help you make the decisions that you're going to need to make during the course of an ITC case. And he can show you with numbers and actual case examples how these things tend to play out. It was a very interesting experience for me several months ago when I met Owen, to really sort of see what I do every day through a little bit, different kind of lens. My mentor, Cecilia Gonzalez, always used to say to me, always be careful about what you think you know. And Owen showed me that really a lot of things I really thought I knew and knew very well, I really didn't know. And, these numbers are incredibly informative. So that's what Owen and I are trying to do here. Owen, can we jump to the next one?
You bet.
So, the first thing you need to think about, right, is am I in the right place? Do I really want to sue in the IT? We've got here over the next couple of screens are things that you ought to be thinking about when you're considering whether the ITC is the right place to be, or do I want to get my client in the ITC? First, if you're looking for damages, if you need money, if money is the thing that your client needs out of the case more than anything else, you're in the wrong place for certain. The ITC doesn't award damages. It only awards two kinds of relief. One is exclusion, which literally means an order to customs that excludes infringing goods from the United States. The other kind is a cease and desist order, which is a kind of, it's sort of like a district court injunction. It precludes companies from doing certain things in the United States, like selling, marketing, advertising, transferring infringing goods, things like that. And we'll talk a little bit more about the remedy as we go. But if what you really need is fast injunctive type relief, the ITC is a great place for you. There's no equitable test as to whether the exclusion order should issue, such as you see in the district courts after eBay. Instead, if you show that the other side has violated Section 337, the goods are infringing, then you get an exclusion order unless the public interests dictate otherwise. So if you need money, you're in the wrong place. If you need injunctive type relief, you're in the right place. It's also a great place to be if you need speed. Now, there are a couple of jurisdictions in the federal courts that are maybe a little bit quicker. Eastern District of Virginia comes to mind, but that's a notoriously difficult place to hold venue. They want to transfer you out of that court unless you really, truly have a dispute that's sort of centrally involved in the Eastern District of Virginia. you don't have those problems at the ITC. There's no sort of venue issues. So it's a very, very quick place to trial. You're going to be in trial in the ITC in about maybe 10 months. So, Owen, there's some things you wanted to say where analytics are useful here?
Yes, and I am now shifting over to my browser to look at some of the data that, oh, wait, I don't mean the Virgin Islands, we meant Virginia. Some of the data that Bert was referring to. And what matters here is that for the first time, you can know in great detail how long a case might take to wend its way through a particular district or an investigation through the ITC. So again, this is just an example, and I'm pulling it up. I haven't looked at this judge before, but I'm pulling him up because Bert just mentioned this district. So, you know, what you'll see here is that if you have been sued in district court and it's been assigned to Judge Trenga, you can come down here and see for a patent case his time determination. This is called the box plot. So the median is 123 days, the lower quartile is 97, the upper quartile is 168. And you can see that same data. He doesn't have any that have gone to trial, but you could see it if he had trials, just how long it took to get to trial in his courtroom. So you can see that data around a district court and then compare it to a particular investigation where, for example, if I pull up an investigation that has, oh, I don't know, let's go to one that has already been terminated, what you'll see, if I can find a good example, here we go, you know, this particular investigation 875 terminated in 109 days. And we'd need to drill in farther to see exactly what that meant, but in general, the data confirms what Bert has said, which is an ITC investigation will almost always move faster than a district court case. So everywhere back now in the slides that you see on the slide some stuff in red, I'm not going to interrupt Bert each time to give the illustration. I just wanted you to have one look into what the underlying data is.
Another thing you want to think about, obviously, and your client is going to want to know, is what's my chance of succeeding? In the ITC, my sense, and I've seen some research that bears this out, is that, you know, you're maybe a little bit better than 50-50 chance of winning if you go to trial in the ITC. It's rather a coin toss. I don't know this, but I guess I'm asking Owen right now. It's a good deal less, is it not, in the district courts, or am I wrong about that?
It depends on the district, and it depends on the judge. So, you know, you're asking here about success rates. If I go into the Eastern District of Texas and I want to look at the outcomes for patent cases across that entire district, what you'll see, interestingly, is that defendants win about 3% of the time and claimants win about 3% of the time. So the perception that claimants always do better in the Eastern District is not borne out by the data. Now, of course, there's a big caveat, which is that most cases settle, and almost 70% of the cases settle, and since those settlements are typically private, we don't know what their terms were, so we can't yet get into the realm of data as opposed to anecdata about whether or not the Eastern District is plaintiff-friendly. But for those cases that go all the way to a dispositive outcome, the data belies the mythology that this is a pro-plaintiff or pro-claimant district. Now, we can look at that same data in the district court, in the ITC, and that we can now do ALJ by ALJ or across all the investigations. So again, just an illustration of how looking at success rates depends in part first on identifying which district court you're comparing to the ITC.
So cost is obviously a big consideration, and I think what I tell clients always is that when you add it all up, soup to nuts, an ITC investigation costs about the same amount as a district court litigation. The difference, of course, is that in the ITC, you're spending, let's say, a $5 million budget really in the space of about 16 or 18 months, and the overwhelming large portion of that, I would say maybe as much as 80% of that, is going to be spent in the first 9 to 12 months. In a district court, let's say you're 2.5 or 3 years to trial, you get that same spend but pushed out over 3 years. And sometimes, it's a tough message to deliver to a board of directors that you're going to take this $5 million and spend it, for the most part in a year. But again, that has more to do with the speed of the jurisdiction and the intensity of the litigation than it does with anything else. It's about the same as a district court case. Who do I name as respondents? This is a very important part of bringing an ITC action. A violation of 337 is based on importation of a good, a sale for importation, or sale after importation, again, of an infringing good. So importation is the person who brings it into the United States. Sale for importation, a classic example, is a component manufacturer, let's say in Korea or Taiwan. They make, let's say, a semiconductor. They sell it knowing that it is going to be imported into the United States in a computer or a telephone or some other sort of thing. So sale for importation is that sort of individual. Sale after importation is, kind of a retailer or a wholesaler or something like that. A respondent has to be one or more of these categories, and frequently when you're in the pre-institution phase and you're talking with someone at the Office of Unfair Import Investigations and they're helping you get your complaint in line, or perhaps even after you've filed and they're reviewing it for pleading sufficiency, it's not unusual for them to say, okay, tell me about this respondent again, and which of these buckets does that respondent fall into? So it's important to make sure that you've identified respondents that meet the sort of statutory description of a violator of Section 337.
And an example of how analytics can now inform the naming of respondents and who you name and how you name is that if you're in front of a particular ALJ and that ALJ has a history of being resistant to naming a respondent based on one of the or more of these 4 particular categories, that may inform your strategy. You might try to do your level best to qualify that respondent as violating Section 337 based on sale after importation as opposed to sale for importation, because your ALJ looks critically at respondents named just for sale for importation. So again, analytics enables you to not only meet the requirements of the law and practice as you know how, but to speak in language that, in this case, the ALJ can hear.
Okay. So the next slide. Thanks. So we'll talk a little bit about strategy. Jurisdiction is obviously important, but generally not a big issue with the ITC. The ITC's jurisdiction to investigate arises from the act of importation. When a thing comes into the United States, the Commission has jurisdiction to investigate whether there's been a violation in connection with that importation. As I said, that's not usually a big issue in the ITC cases. Discovery is a very big strategic consideration. It's becoming even bigger lately in terms of who do I need to name as a respondent in the case. Domestic third parties, it's difficult to get discovery from a domestic third party in an ITC case, and third parties are sort of getting smart about this, and they're fighting harder against having to produce information in response to a subpoena.
And Bert, that's an example, again, where using the analytics can inform your strategy about who to name, because if you go back through the data and it shows that a particular party has fought to the death every discovery request, every other time it's been named as a respondent, that might inform your decision about whether or not to name them as a respondent in your case.
Right. So if let's say you have a third-party manufacturer of a component, you can accuse of infringing the people who are using that component, but you might need discovery from that third-party manufacturer in order to prove your case. If you do, and that third party is of the kind that Owen just described, you might want to name them as a respondent in your case. If they're a foreign third party of that type, you really need to think very hard about whether you want to name them and bring them into the case, because you may not. In fact, if they're a foreign third party, you probably will not get sufficient discovery. It's a very difficult thing. So and there are reasons why you might not want a component manufacturer in the case. Since the Kyocera decision a couple of years ago, you really don't get much from an exclusion order against a component manufacturer. So, because you have to really go after the things that are imported into the United States, and you have to name those people. So let's say in a telephone case, the chip could be made by company A, but it's really imported in a phone by company B, and you can't exclude all of the chips made in the phones that contain chips made by company A unless you name company A in the case. You might not want company A in the case if you can name all of the downstream manufacturers, because company A is probably the one who's going to know the most about the chip and is in the best position to beat you at trial. So this is a bit of a balancing act, right? How much do I need them in the case in order to get the discovery I need? And, wouldn't it be nice if they weren't in the case, that I wouldn't have to fight against the party best positioned to beat me? So, there's a lot of these kinds of decisions and trade-offs that you have to make. Again, in terms of remedy, we talked a little bit about this before. The exclusion remedy is an in rem kind of remedy. So, if the commission has jurisdiction over the thing that's imported and it has jurisdiction over the act of importation, exclusion is the sort of interruption of importation, right? Customs will exclude from entry those goods that are subject to an exclusion order. Cease and desist order is a little bit different. It's generally directed only to U.S. entities, because where the commission has to police an exclusion order, it wants to know that if it goes to district court, it's going to have jurisdiction over them. And it's also against U.S. entities that have commercial levels of inventory in the United States. The point really of a cease and desist order is to freeze the inventory that's in the United States, and it can be a very, very useful remedy when you can get it.
Bert, what I'm showing here is a list of all the ALJs and how often they issue a cease and desist order, along with everything else they do, which can inform your strategy. If you're assigned to ALJ Essex, who less frequently and with more reluctance will issue a cease and desist order, this data might suggest that you want to try to get to a different ALJ, or at least pursue a different strategy in front of that ALJ, given their past behavior around all the different outcomes that you can get at the ITC. So I'll go on to the next. Here we go.
16, right. So again, strategy considerations, and I have this last, but it might have been first and really probably should be first. We're all familiar with the Clausewitz doctrine that war is diplomacy by other means. And really, litigation is just business by other means. It's not a thing unto itself. It's not an activity that exists in a vacuum. And what I always tell people, and what I always try to do in my practice, is to always keep the business goals in mind. And those sometimes change, right? There's kind of shifting sands in the business world. And it's very, very important all the time to know what are the business objectives of the company in the litigation. What do they want out of the case, and what will they accept? This is maybe the most important thing to keep in mind all the time. And so again, when we're thinking about naming respondents, those business objectives, those business relationships, the goals of the people in business, who do they want to do business with in the future, who do they not particularly care if they do business with in the future, who would they prefer to destroy in business in the future. Those are all things that sort of go into this, and it's critical, really, for you as a lawyer bringing this case to really understand how your client understands the business terrain into which the litigation fits. I don't know, Owen, if you want to talk to this last point about past behavior of parties in district courts. I think you mentioned it earlier.
Yeah, I think we touched on it earlier, and we can look at it a little bit more before we end up this webinar today. If we have time, we can look at some individual parties. But certainly a big strategic consideration is how has this party previously behaved both in the district court and ITC settings, so that you go in with eyes wide open about what you can expect from them in response to your complaint. So, Bert, patent infringement.
Sure. So patent infringement is, a way of showing a violation of 337. Remember, 337 is an unfair act in connection with import trade. The most popular way of showing an unfair act is patent infringement. And, I don't know this. I'm sure Owen could figure this out, but I would bet it's more than 80, maybe 85% of cases that are tried in the ITC are patent-based cases, maybe even more. So it's overwhelmingly a patent jurisdiction. And all kinds of infringement. Certainly you can show it by direct infringement. You can also show it by indirect infringement. When the case all sort of gets boiled down to its essence and you go to trial and you're having these things decided, it really looks a lot like a district court patent litigation. So you show infringement in the same way that you would, for the most part, in the district courts. So indirect infringement applies, doctrine of equivalence applies. All of the ALJs, however, require that you explicitly flesh out doctrine of equivalence in your pre-hearing brief. If you don't, you just call it infringement. Chances are you'll be found to have waived doctrine of equivalence. The Commission is a very good case to try a patent case, or a very good jurisdiction to try a patent case. I find that the judges really understand patent law. If you think about an ITC ALJ in comparison to, say, a district court judges hear all kinds of cases, contract cases, criminal cases, drug distribution cases. They hear any manner of commercial litigation, and only occasionally do they hear patent cases. And that's true even in places where patent cases are a big chunk of their docket, like in Delaware or the Eastern District of Texas. It's not what they do every day, all day. In the ITC, this is what they do. They understand patent law very, very well, and they get it right, certainly more often than not. Same is true of the commissioners and the general counsel staff, the Office of Unfair Import Investigations, and the commission staff. They know this stuff. They're familiar with it. They do it every day. And that's a real strength if you've got a good case. Patent claims and the construction of patent claims are not mysteries to these folks. They understand it. Again, they do it every day. Complex technology, I've been in district courts where you start talking about, let's say, express genes or technologies like circuits and very sophisticated double E technology. And you can see the judge just wants to be any place else. This is really not something they want to decide. That's not true in the ITC. The judges in the ITC, again, hear this every day. They're not afraid of technology. They learn it, and they do really a pretty extraordinary job. The flip side of all this is that they're not intimidated by, your fancy blue ribbon on your patent. They don't think that patents are really something super special, this wonderful sacred grant of right by the U.S. government. If you've got bad claims and you bring them to the ITC, it's a place where the judges are not afraid to invalidate. So,
you'll see here, Bert, on my screen, I've pulled up all investigation outcomes, and no violation is found in this case. Since for easy math, we're up to almost 900 investigations, and you can see that a violation is found almost as frequently as no violation is found. Now, there are more than one outcome usually associated with a particular investigation, which is why if you add up all these numbers, they add up to about 1,200 as opposed to the close to 900 investigations per the ITC case numbering. But the point is that no violation, Bert's assertion that these ALJs will not stand for shaky claims is borne out by the data. They are absolutely willing to find no violation if they find that your underlying patent claim does not have merit.
And that is why selecting the patents and the claims you're going to assert is very, very important. That almost goes without saying. I'm sure everybody here on the phone understands that. But, doing a very, very thorough and sort of objective due diligence is really, really important because, again, if you don't have a good case, if you've got shaky claims, you will lose. And the judges, they're not, there's no bias here in favor of complainants, and there's certainly no bias here in favor of patents. They'll call them as they see them, and they're not afraid to find them invalid. So, again, due diligence here is very, very critical. Find your strongest claims. Make sure you've got a high level of confidence on your infringement theories going in. I always tell people, make sure you talk to your inventors. This is a terrible thing to say, but again, I know a very successful person in this profession who always says the only good inventor is a dead inventor. So if you've got inventors who are still alive, make sure you interview them and really, really have a high degree of confidence in their ability to testify before you file the case.
I'm noticing that we've got about 20 minutes left in our presentation, so Bert and I will do our best to speed it up so we get it all to you.
Sure. Why don't you go ahead? So slide 19 is just basically showing what we already talked about. It's not an exclusively patent jurisdiction, but it's overwhelmingly so. Let's move to temporary relief, and really the only point here to make is it's in the statute, it's provided for, but it's a very, very difficult jurisdiction to get temporary relief. You have the four-factor test that you see in the district courts: likelihood of success on the merits, irreparable harm in the absence of relief, balance of hardships between complainant and respondent, and the public interest. Likelihood of success on the merits in the ITC is traditionally very, very tough to show. And I was thinking in very absolute terms here. If I've got patents that were successfully litigated before in some other jurisdiction or in the ITC, I'll take my chances in a TEO proceeding. But if I don't, I've already got myself a very, very fast jurisdiction. I'll just go sort of the normal way, I think.
And again, the reason why the note about the difficulty of obtaining temporary relief at the ITC is in red is because this is now a subject that you can drill into via the data and see how often temporary relief is provided by the different ALJs and in what context.
So can we move to 21? Yeah, we're there. Okay. Actually, move to 22, please, Owen. The public interest is an old part of ITC jurisprudence. It's as old, I think, as the statute. But in the last 5 years or so, really since the Broadcom, Qualcomm cases in the 2005, 2006, 2007 timeframe, public interest has become a very, very important part of what the Commission talks about. And they talk about it more and more. And there's a great procedure given over to figuring out whether the public interests are affected by a remedy that's proposed. So nowadays, there's been some rule changes where the Commission accepts statements on the potential impact of the public interest, of the remedy on the public interest when you file your complaint. Members of the public and the proposed respondents have an opportunity to respond to that. And what I've listed here at the bottom of 22 and are just sort of the factors that you take into account when you're thinking about the public interest. Go to 23, please, Owen. The Commission can take that and factor into their own view of the case and decide sort of how to handle these public interest thoughts. They can just maybe not institute the investigation at all. They can institute it, but maybe authorize the ALJ to look into public interest in particular during the course of the case. They can institute the case, but not so authorize the ALJ. These things are sort of variations, and I think the Commission is sort of developing now a kind of disciplined way of thinking about which cases deserve a deeper public interest look than they had in the past, I think.
I'm just going to, just for illustration, pull up in ITC docs the frequency with which there's a reference to the public interest, just to illustrate for folks that it is a subject matter that infuses your entire investigation, regardless of whether or not it...
Owen, are you with us?
Yep, can you still hear me?
Okay, yeah.
Bert, are you still there?
I am, yes.
All right, you want to go on to the pilot program?
Yeah. First, I'm going to talk about public interest and a recent development in public interest that is just very important for everyone to keep in mind. Samsung obtained from the ITC an exclusion order directed to certain Apple products. The 337 statute provides for a period of 60 days for the President through the USTR to look at the Commission remedy, and for its own reasons, whether they're public interest reasons, public policy reasons, trade policy reasons, whatever the President thinks of that as, to disapprove of the remedy. And for the first time in nearly 2 decades in this case, just in August, I think it was August 3rd or 4th, the USTR disapproved of the issuance of the Commission exclusion order for Samsung against Apple. And what they asked the Commission to do was to pay a lot of attention to developing the public interest record as it relates to the assertion of standard essential patents. This is, on its face, a very important development, and certainly just by dint of it being exceptionally unusual, it's important. There's also a great deal of public debate in almost every policy body I can think of that worries about these kinds of things, about whether someone should assert or be able to assert a standard essential patent and seek injunctive type relief. So this kind of falls within public interest. I think when it all boils down, what the President is asking the Commission to do, I think they already did in their deliberations. They did make a very, very thorough record on these issues, but the President is clearly uneasy with these kinds of orders, at least in the context of standard essential patents. And it remains to be seen whether this is a kind of one-off sort of political event or whether this is a very thoroughgoing, far-reaching policy decision by the President. But this is a very interesting development just in the last couple of months. Another interesting thing that the Commission is working an awful lot about is domestic industry and what kinds of companies can be domestic industry. So at a very high level, in order to win an ITC case, you have to show that you are a company that has investments in the United States that are sufficient to qualify as a domestic industry. One way you can do this is by being a licensing program. You can do it by having an R&D program. You can do it by actually making things in the United States, actually manufacturing. So there are a number of ways you can do this. But the ITC is taking a very, I will say, fresh and perhaps even hard look at domestic industries and who can qualify. One of the ways to doing this is this pilot program that they've instituted a short while ago, where they say sometimes they will ask the administrative law judge to take an early look at whether the complainant really can show that they have a domestic industry. And in fact, they did this in the 874 investigation. They asked the ALJ, who turned out to be Judge Essex, to really look into this. He did so. I think he had some issues with whether the commission had the authority to ask him to do that. But in any event, he did it, and he decided that the complainant could not prove domestic industry. The commission reviewed it and affirmed the ALJ and found that, in fact, the complainant could not show domestic industry and the case was terminated. So this is an example of the commission doing what it said it was going to do and take an early look at suspect domestic industries and where the complainant cannot show that a domestic industry exists, getting rid of the case. I think their view of this is that it's important not to have litigation, expensive litigation at the commission that looks to remedy violations on behalf of domestic industry that really is not important or doesn't exist at all. So it's, again, an interesting thing that's happened at the ITC in just the last couple of months. So let's look at the next one. Yeah. So the statute provides that all legal and equitable defenses may be presented. You can even counterclaim in the ITC, but that doesn't happen very often, and when it does, the counterclaim is immediately moved to the district court. Can we go to the next one, Owen? So we can sort of gloss through these, and maybe we ought to, in the interest of time. Really, what all of these at the end sort of boil down to is that once a case is begun, you can withdraw portions of it or even all of it, but the commission is only going to make appealable decisions in terms of violation. And there's, you can terminate an investigation for reasons that are actually enumerated in the statute, settlement agreement, and this is on slide 27, Owen, if you want to stay with me. Consent order or arbitration. The commission will make decisions on the merits as well, obviously, but the only appeals provided for in the statute are on merits and a few sort of special circumstances. There was one case very recently, though, where a termination in favor of arbitration was made by the commission, and it was appealed. The party that was looking for arbitration there said to the Federal Circuit, you don't have jurisdiction over this, it's not one of the enumerated things in the statute. And the commission actually, or the Federal Circuit actually said, no, when the termination has the effect of a final termination, we will hear the merits of that kind of appeal. And so they reached out, they heard the merits, and they actually reversed the commission. That's subject now to a petition for reconsideration, and we'll see how that turns out. But this is, you know, a kind of exception to the express standards of the statute. Owen, did you want to take it from here? The rest of these things, I think, are really more of what we were just talking about. Okay.
Well, thanks, Bert. What I want to do now, in the couple of minutes we have remaining, is provide a couple examples of the kinds of questions that can be asked and answered using legal analytics in an ITC context. And what better example to start with than Bert himself, where you'll see I've pulled up here all of the district court cases where Bert has been an attorney of record, all of which you can click in to see more about who he represented and what kind of strategy he used and what the outcome of the case was. In fact, you can actually click through now and see his client list, because that's all built bottom up from the docket events and documents that comprise the record for all of these district court cases. Similarly, you can see the investigations that Bert has participated in at the ITC. So whether your client, if you're at a law firm, or whether your company, if you're in-house, is served with a complaint or is the subject of an investigation initiated by Bert, you can drill into the data to try to peel back the layers and see how you should respond when he's representing the complainant. Or if you are an in-house attorney and you're looking to hire a law firm, an attorney to represent you in an ITC proceeding, you can go into this data and see how well Bert does and see how well others do and try to find the law firm and attorney that has the right sort of experience substantively as well as a history of results that you want. So that's just an example about how data about law firms and parties can inform not only the selection and management of outside counsel, but also the substance of your strategy as a complainant or as a respondent at the ITC by looking at the behavior of opposing counsel. Similarly, this same data is available for judges. We mentioned it earlier that we've got very granular data for district court judges. I now say we know better than they do how they behave. We know to the second decimal point how they rule in patent cases. Well, we're on our way to having that similar level of insight into the ALJs at the ITC. So here you'll see, for example, among the current ALJs, those that are still serving, that Judge Bullock has had almost twice the number of total investigations as Judge Essex, his nearest competitor. So Judge Bullock is far and away the most experienced ALJ at the ITC. Similarly, you can see, in fact, when Bert and I were at the event sponsored by Momentum in June in D.C., and we first gave this talk, Judge Bullock happened to have been in the room and was sitting around the table with us, and I said to him, would you like to see the data about yourself? And he said, sure, why not? And I said, did you know that you had 92 investigations under your belt? And he said, no, I didn't know. And I said, among those terminated investigations, did you know that you've issued a general exclusion order 9 times, or a limited order 15 times, or that you found no violation 9 times, and that 39 of them have settled, and that you've only issued a cease and desist order 8 out of 92 investigations? And he, to his credit, he looked both shocked and interested. I think it's always a stutter step of a moment for an attorney or a judge or those involved with a particular company or party to confront head-on the amount of information that we now know about you. But he got over it pretty quickly and was very excited to see this data. And just like all judges, the first question they always ask me is, what's my data, what's my data? The next question they always ask is, how does it compare to my peers? So, of course, I showed him some of the data for Judge Essex and some of the other ALJs, which, of course, he found very interesting. But you, as an attorney at a law firm or in-house, will certainly want to use this data to try to understand which ALJ you would most want to handle your matter, and alternatively, how an ALJ will behave once it's been assigned to that ALJ. So, again, examples of using the data around attorneys and law firms, using the data around judges, or in this case, ILJs at the ITC. I can go on and just in these last 2 or 3 minutes, I'm obviously not going to cover a lot, but I will show you that for a particular investigation, and I'll pull up any old one here, what you'll see we now know is a great deal about the patents that are at issue in that investigation. So, this particular patent relating to a thumb drive has been the subject of 26 different district court cases, but never been the subject of an ITC investigation, while the final of the 3 patents involved in this investigation has been at issue in 7 district court cases. It has been at issue in 1 other ITC investigation, in this case these 2, 019 and 843. So you now have a lot of information upon which to engage in analytics around the subject of the dispute itself and not just the participants in the ecosystem. So as good as the data is about lawyers and law firms and about districts and judges, or in this case ALJs at the ITC, or about particular parties, there's now a great deal of data that's been assembled bottom up about the patents that are themselves the subject of these investigations. So that is just a quick look into some of the data that is available. And if you need help with an ITC matter, feel free to contact Bert. If you need access to information about the ITC, feel free to contact me. All of it, again, bringing it full circle to Moneyball, is that we hope you win the Commissioner's Trophy or whatever its equivalent is in your ITC matter. So Bert and I want to thank you very much for spending this hour with us. We want to make ourselves available if there are any last-minute questions. Otherwise, we'll throw it back to our friends at Momentum to round up, to end this event.
Just thank you both very much, Owen and Bert, for today's presentation. That was really fascinating. And as Owen and Bert both said, the slide deck will be made available, and if anybody wants to contact me directly, I can kind of mediate and make sure that you receive the presentation for this. There will be a video of this webcast available as well, which I will make available online too. But with that being said, we don't actually seem to have any questions, but if anybody thinks of any questions, has anything subsequent to the wrap-up of this session, please do let me know at matt@momentumevents.co, and I will make sure that they get to the correct individuals. With that said, I want to thank you both again, Bert and Owen, for a fantastic presentation, and that concludes this webinar. Thank you very much, and have a fantastic day, everybody.
Thank you.